Decoding American Hypocrisy.
Great. Thank you so much, Aarti. And thank you to the Indic Researchers Forum for organizing this event. Namaste to everyone. Good evening or good morning early good morning from here in California. It's great to be here with all of you today. Before I get started, I actually wanted to put in a little plug. Michael was talking about some of the funding sources, and the Middle East Forum actually does a fantastic job of tracking funding sources of a lot of the front charitable organizations and how they have manipulated the 501c3 nonprofit system in the US and how they're using that funding to fund a lot of the activities that we're seeing, a lot of the Islamist groups in particular. So just wanted to get that plug in first before I get started. But today I'm going to really focus my remarks on the Citizenship Amendment Act in the context of the Lautenberg-Specter Amendment, the American reaction to that, and the motivations behind it. So if you recall in 2019, when the Indian Parliament passed the Citizenship Amendment Act, there was quite a vocal reaction from the American establishment. While some may say it's not surprising, it was perplexing though on many levels. If we look at some of the legal precedent and we also look at some of the similarities in refugee policies between the US and India. In fact, a humanitarian bill such as the CAA should have been welcomed by the US, not just due to the growing bilateral relationship with India, but also given America's long track record of providing shelter and refuge to persecuted communities from around the world, which was very much similar to India's. And after all, the CAA was doing what the US had already been doing for decades, providing a fast-track path to legal status for refugees escaping religious persecution from a very select specific group of countries. The CAA was even more narrowly tailored and limited in scope compared to the similar US policies on refugees and asylum. So for example, the CAA was actually aimed at addressing an already existing refugee crisis, which was created by, of course, the long shadow of partition and exacerbated by subsequent social, religious, and political dynamics in 3 of India's neighboring countries. More specifically, it simply reduced the residency requirement for naturalization and provided a fast-track path to citizenship for the named minorities, Buddhists, Christians, Hindus, Jains, Sikhs, and Zoroastrians, who have, of course, had escaped religious persecution in Pakistan, Bangladesh, and Afghanistan, and importantly, were already in India on or before December 31st, 2014. The law had zero and does have zero impact on any existing Indian citizens, whether Muslims or anyone else. So despite the clear intent and scope of the CAA, the reaction and misinformation from many quarters in the US, including government officials, think tanks, the media, academics, and activists, has been quite astounding. In particular, the political fervor to comment and censor India on the CAA, particularly amongst Democrats, but not confined to them, resulted in resolutions from the likes of Congresswoman Ilhan Omar, all the way down to local city councils in major cities across the country. These resolutions falsely proclaimed the loss of India's secular fabric and that the CAA posed a risk for Indian Muslims, including the possibility of rendering millions stateless or subject to indefinite detention. The narrative about the CAA has continued at a low level since 2019. Of course, there have been many other issues that India has been attacked on. But again, the announcement earlier this year by the Indian government to notify the rules for the CAA brought renewed criticism from some American policy circles, most notably the State Department, the US Commission on International Religious Freedom, which is a quasi-government body, and some members of Congress. So what has led to the American criticism of the CAA? Who has been pushing that agenda and why? Before I delve into those questions, I want to first briefly touch on US immigration policy vis-a-vis refugees and asylees, with a particular focus on the Lautenberg-Specter Amendment. If we look at American immigration and asylum and refugee policy, although the framework for refugees and asylee determinations on the surface seems to be consistent and has a consistent framework, the decisions on whether to grant specific asylum to specific applicants or approve large refugee migrations have always been based on highly biased and political decisions, ranging from national security concerns to perceptions or the reality of human rights in particular countries. For example, for many years, the US accepted large numbers of refugees from countries such as Cuba, China, and the former Soviet Union, just to name a few, because of relations with those countries. One of the more prominent examples of such refugee programs is known as the Lautenberg Amendment. What is the Lautenberg Amendment? We've heard that name thrown out a number of times when talking about the CAA. So the Lautenberg Amendment was introduced by former Senator Frank Lautenberg. It was initially passed in 1989 and went into effect in 1990. Like the CAA, it provides a clear immigration path for specific groups of persons fleeing select nations where religious persecution is rampant. Senator Lautenberg created a legal presumption of refugee status, a fast track for certain religious minorities. In other words, unlike other classes of refugees, those coming under the purview of the Lautenberg Amendment did not have to prove that they faced a well-founded fear of persecution if they met certain eligibility requirements. And under the Lautenberg Amendment, the US Refugee Admissions Program allocated admissions among refugees of special humanitarian concern to the United States in accordance with a determination by the President after appropriate consultation. So this family reunification program under the US Refugee Admissions Program allows certain individuals legally residing in the United States to actually apply to bring their family members and friends to the US as refugees. It authorizes citizens of the former Soviet Union to be with their relatives in the US. This is done by granting them presumptive refugee status. The amendment specified that Jews and evangelical Christians from the former Soviet Union, as well as members of the Ukrainian Catholic and Ukrainian Orthodox churches who were experiencing government persecution and discrimination, could utilize the refugee program to seek shelter in the US. So tens of thousands of refugees from the former Soviet Union have come to the US under this program. Now, in 2004, the Lautenberg program was actually expanded even further through what was called the Specter Amendment, spearheaded by former Congressman Arlen Specter. The Specter Amendment allowed religious minorities in Iran to find refuge in the US, including Jews, Christians, Baha'is, Sabian Mandeans, and the Zoroastrians. So Lautenberg, Specter combined together requires that people that want to come into the program show an inability to study or practice religious beliefs or ethnic heritage, or they have been denied access to educational, vocational, or technical institutions from which they would be otherwise qualified, and they have faced some adverse treatment. But again, there's a presumption of that if they meet certain eligibility requirements and have a certain religious identity. And for the purposes of refugees from Iran, the program also requires proof of religious affiliation from one of the minority religions listed in order to qualify. Overall, this Lautenberg-Specter program was well-intentioned legislation that arose out of a very specific geopolitical and historical context and was necessary to alleviate the suffering of Jews from the former Soviet Union and religious minorities from Iran, who indeed did face systematic human rights violations and religious persecution. So now let's look a little bit at the Lautenberg-Specter versus the CAA. The CAA is no different in that it arose out of a specific geopolitical and historical context and is intended to help a very small group of persecuted religious minorities. And while there are technical differences between these two programs, the humanitarian spirit and intent of both are largely the same. So if one is going to criticize the CAA for leaving out minority Muslim sects from Pakistan, Bangladesh, and Afghanistan from its purview, that same exact criticism can and should also be levied on the Lautenberg-Specter program, which has left out Muslims from the former Soviet republics, as well as Iran from qualifying, even though they too have a history of facing discrimination. But both programs raise important points and have left out certain categories of minorities or religious groups for particular reasons. First, Muslims can still immigrate to both the US and India through other means, and in fact have. In India, for instance, of Afghan, Bangladeshi, or Pakistani Muslims seeking Indian citizenship can still enter under normal immigrant and non-immigrant pathways and live in the country for regular residency threshold and apply for citizenship like anyone else. Moreover, Afghan Muslims have been given refuge, while a number of Bangladeshi Muslims were given Indian citizenship after the 2014 settlement of Indo-Bangladesh boundary issues. And in the US, Muslim dissidents from Iran have come to the US as asylees, while Muslims from Afghanistan, Iraq, Libya, and many other countries have been given refugee status and asylum, not to mention those that arrive on other normal immigrant statuses. Second, and perhaps more importantly, neither the Lautenberg-Specter Amendment nor the CAA have any impact whatsoever on the rights of existing citizens in both countries, particularly Muslim citizens. Then why has there been such a misguided outcry of concern and the false accusation that India has established a religious test for citizenship excluding Muslims, despite the fact that India has not made a single change to the rights of its existing Indian citizens, and the US has a near exact law in place regarding religious refugees? If anything, as I mentioned, the CAA is actually more narrowly tailored and limited in scope compared to the Lautenberg-Specter program. The CAA only applies to 3 countries, while Lautenberg-Specter encompasses refugees from 16 countries. Furthermore, the CAA is limited in time period, meaning that it's only valid to refugees that are already in India prior to December 31st, 2014, which I would argue is actually a flaw and it should be expanded. But the Lautenberg-Specter Amendment actually allows specific refugees to come to the US on an ongoing basis and now has been in effect for 34 years. So why are US policymakers and others commenting on the CAA? Ultimately, it's because that the Democratic Party, the mainstream media, and other analysts have either no regard for facts, which is highly unlikely, or have fallen prey to a sophisticated and systematic lobbying campaign by a highly connected ecosystem of organizations and individuals who use this opportunity to discredit India and undermine US-India relations. And this actually aligns with the interests of some within the US administration itself, including within the State Department, who do not want to see strong relations with India. That's why the rhetoric from some of these groups claiming that the CAA was passed with the express purpose of revoking the citizenship rights of millions of indigenous Indian Muslims was accepted without question. And not surprisingly, many of the groups attacking India for the CAA, including the Council on American Islamic Relations, the US Council of Muslim Organizations, which is an umbrella organization based in Washington, D.C., Indian American Muslim Council, Islamic Circle of North America, and many others are the same ones now organizing anti-Israel campaigns, undermining US-Israel relations, and engaging in grotesque anti-Semitism. Not far behind are the far left Indian Marxist groups, such as Hindus for Human Rights, and even some purportedly mainstream Sikh organizations like Sikh Coalition and Sikh American Legal Defense Fund, who harbor Khalistan sympathies, have attacked India for the CAA. Ironically, despite the fact that the CAA benefits persecuted Sikhs from Afghanistan and Pakistan. Notably, Hindus for Human Rights and these Sikh groups have also supported anti-Israel and anti-Semitic activism going on currently on college campuses. The US policy establishments needs to wake up and recognize that the same ideological compunctions that have driven the anti-CAA lobbying campaign have now pivoted to focusing on Israel. This ideology and the groups that are spearheading it are hurting US domestic interests as well as harming countries such as Israel and India. Instead of focusing on humanitarian laws in India, policymakers need to confront this ideological initiative, both from within the establishment and outside of it. If US government officials do want to comment on or take a position on an issue like the CAA, they should first take a look in the mirror and change the Lautenberg-Specter Amendment and other refugee policies domestically. Otherwise, they should respect the internal policy decisions of a democratic, pluralistic ally like India and keep quiet. And with that, thank you very much, and I'll yield back my time.
Thank you, Samir.